defects which have been detected later on.
And I have filed already the reading notes about it.
I know you want to take it back because they want liberty to file a fresh. I'll give it back to you.
No.
The written notes of arguments which have been filed by the learned counsel for the opposite party is returned to the learned counsel. Dismissed as withdrawn with liberty to file afresh with proper particulars. Cost of ₹1,000 be paid by the opposite party to the opposite party before such filing.
I'm grateful, Lordship. I'm deeply obliged.
You want to take back these judgments?
All right.
Respective ones?
It may be.
You can take it back. এই যে এগুলো একটু লিখে দিয়ে দাও জয়কে ওইখানে দিয়ে দাও। আর ওই
এটা স্যার আপনি দিয়ে
এটা ওকে দিয়ে এটা ওর হবে your matters
এটা আমার
এই এটা এগুলো ফাইল yes
I'm
next
deeply obliged.
yes next matter please.
I mentioned the matter yesterday.
This is a motion.
Motion.
Okay.
Lord, kindly see, Lord. The
Dekhi daw.
opposite party, Lord, filed an application before the
The matter is taken up as an urgent motion on mentioning of the learned advocate for the petitioner. As there is no caveat, the matter can be taken up today in spite of the resolution. Yes.
Lord, kindly, your Lordship, kindly come to the father filed an application before the maintenance tribunal under the.
I mean, Mr. Ghosh.
No.
Where is the deed of gift?
Lord, your Lordship, it has not been annexed, but I am
We
trying
give a
to
copy.
give.
File
Lord.
it with a supplementary affidavit later on.
Yes, Lord.
It will be easier. when
Lord,
the
kindly
matter-
see, Lord, this is
Take it
the
out of you.
relevant person. There is no condition, Lord, nothing else. It was in 2016 in favor of the minors. They have attained majority. Others accepted the gift as guardian.
দানপত্র দানদাতাকে দান গ্রহীতা হচ্ছে নাবালক শ্রী পীযূষ কোলে
Yes.
take down an arguable case has been made out by the learned advocate for the petitioner in the prima facie view of the court. The learned
Appellate tribunal.
appellate tribunal
Lord, kindly see the order. Page. This page 16.
under the Maintenance and Senior Citizens Act would not have declared the deed as void for the following reasons. A, the prima facie view of the court. No condition of the donees to either supply the essentials or provide for the sustenance of the donors had been made in the deed of gift. The gift was unconditional. The donees were not made parties to the proceeding, and they were not the children of the donor but the grandchildren. Stay of operation of the order dated
11th May.
May, huh?
May
11th
11, 2020.
May 11, 2022 for up to November 30. Insofar as the portion relating to declaration of the deed of gifts to be void is concerned.
Yes.
Other part you have to comply.
Yes.
The directions passed in serial number 3 shall be complied with,
Yes.
or the order impugned shall be complied with. ওখানে ওই maintenance এর কথা বলেছে,
Well,
সেটা
let him learn.
তাকে ফেরত দিয়ে দাও।
Possession may not be interfered with, because on the basis of this cancellation, they are trying to say,
Stay of operation and status quo of the possession be maintained.
yeah,
With regard to the possession of the property in question be maintained.
but
Yes.
it-
Two deeds of gift.
Yes.
2 deeds.
3.
3 deeds. 3 gift deeds are কিন্তু। In respect of the properties involved in the list, LIS be maintained. Yes, next.
Returnable, my lord?
Returnable 30 November অবধি দিয়েছি তো। 22 November, 2 PM.
Grateful.
All right. Service ওগুলো যে
Yes.
advocate সবাইকে। Yes. Next.
I'm for the applicant, Madam. This is my filing.
1 minute. Let the file up. Yes.
But the matter was considered on 17th of May 2023 by His Lordship Honorable Justice Day. But there was a direction upon me to serve up the copy. Well, I have served the copy. There I am stating that also that this will be mentioned before your
Not
Lordship.
today. Today there's a resolution. And why is it in the top urgent matter?
Well, on 24th I mentioned because the next date is on 4th. I mentioned.
No, but these were moved earlier.
But we moved before Justice Day, but
No,
thereafter.
maybe, but every time bench changes, once
No.
it's moved, it's
No,
moved.
but the matter was made.
Hearing matter,
Uh,
how we are urgent motion,
But the matter was made returnable on 26th of June.
maybe.
Thereafter I
As a
mentioned.
hearing matter, then anyway, not today.
No.
Next. I've got the order. Yes.
Your Lordship, I am on behalf
All
of
right,
the
1 minute.
petitioner.
I know, I remember.
Hmm.
All of, is it, there's no caveat?
Yes, in the sense that the caveat is actually not against me, but against the wife of the petitioner.
Huh?
But the opposite
Who are you?
party, I'm the petitioner.
Who is the petitioner? Is your
This
wife
is-
is not a party
No,
and caveat is against the wife.
yes,
What does that mean?
no, it is regarding the same suit property that I was a part of the co-sharers.
What is this matter about?
The matter is that I am already dispossessed and it was a title suit that
At the
the final
order
decree has passed, but I have not given the
You have not been supplied with the
certified copy even till date.
But you want title execution case records and all that?
No, I want the, from the court, I want the help of giving direction to the learned Badipur court to look into this matter
Your
of certified
prayers, What
copy.
is your prayer?
The prayer, Your Honor, the prayer is for this, certified, to get the certified copy.
No, that is
And-
not your prayer. Come look at your prayers, please.
Yes,
Do not
yes.
make an extempore speech.
No,
Read
no.
your prayers, please.
Yes, page 19, Your Honor, call for the record of title suit. And
Yes,
number
yes.
2 is,
Record
on
of
here-
the execution case.
yes, yes.
Why you want the records? If you don't have the copy, the direction for issuance of copy. The revision
Record of title
application
suit
has been filed.
6192 along with the execution case. And number 2 is on
Madam, if you go
restraining.
on rattling like that, it will be
Okay.
difficult for me.
Okay.
You have prayed specific prayers about wanting some copies, documents to be sent to this court, and a rule as to why orders shall not be passed, restraining them from changing the nature and character. These are your prayers. You are telling me you want the certified copy. What do you actually want in this revisional application? These orders, if you want, I can't pass it today. If you want, simply sit at an order of on the learned court below to supply the final decree to you, which it's not been drawn up.
No. The final decree already passed, execution already done, but still date, whenever I have applied for the certified copy of the final decree to file an appeal in the Honorable High Court, I have not given the certified
Why?
copy. Because the record is not being found.
Okay.
And for
The
that
revision
matter,
application has several prayers which are not entertained by this court. Hence, the matter is taken up and disposed of in the absence of the opposite parties. This court finds that justice would be subserved if the petitioner is allowed copies, is supplied with a copy of supplied with a certified copy of the judgment and decree dated. Tell me the date.
dated 14/2/2007 of 6192, title suit number.
You want a stay of the execution. So are you sure that you don't want to press any other prayer here? You are saying because you could not get the decree, you
Yes.
could not file the appeal.
Yes, Your
In the
Honor.
meantime, they are proceeding with the execution.
Execution already done on 10th of April of
Oh,
this
you have
year.
been dispossessed.
Yes, Your Honor.
Oh.
I'm now at the mercy of
Clearly, the
others.
revisional application
So-
has now become infructuous in view of the subsequent dispossession of the petitioner from the suit property. However, it is the court finds it astonishing. Now, the court finds the prayer of the learned advocate for the petitioner to be rather surprising. It is submitted that the certified copy of the judgment and decree, final decree, passed in title suit number 61 of 1992 has not yet been supplied to the petitioner, as a result of which the petitioner is unable to prefer an appeal. The revisional application is disposed of without any orders as prayed for. However, the learned civil judge, Junior Division, Baroipur, South 24 Parganas shall ensure that certified copy of the judgment and decree passed in title suit number 61 of 1992 is supplied to the petitioner and or the learned advocate of the petitioner within 2 weeks from date of communication of this.
And Your Honor, that they are
the-
trying to dispose of the,
I cannot do anything about.
when
But-
can they be restrained, Your Honor? Because the next date is on 1/8.
No, they
Of-
cannot. You prefer an appeal in the meantime and get an order. Yes, they have already taken possession through proper process. How can I restrain them now? There has to be an appeal. I cannot do it in the vacuum, right? Yes. The prayer for the other prayers with regard to the future. Now, the prayer made by the petitioner with regard to a restraint upon the decree holders. Your partitions, you find the partition suit.
No, no.
No,
It's at the learned-
the other prayers with regard to the user of the property by the persons who have taken possession by virtue of the upon execution of the final decree cannot be passed in this proceeding. The petitioner is at liberty to approach the appropriate forum in accordance with law. Yes, next.
No, ওটা কিছু করছে না।
Next, are you for the other side?
Well, actually, Mr. Mukherjee is appearing on behalf of the plaintiff
The
opposite party,
caveat
Which party?
Mr. Omol
of this-
Kumar Mukherjee.
Give the name. Because I am saying the prayers have become infructuous. Execution is over.
So
They have-
because it's a suit,
Yes, all right.
Well,
Next,
well,
next, Dakota.
well, against the suit,
How
well,
will
revision is
you
not applicable.
Give the final
That
decree
is
to them.
executed, it must
Husband
be,
and-
by
Maybe
degree is
she
executed.
will prefer an appeal.
Yes.
So give the names of the learned advocates, please. Whoever is appearing, give the name, it will appear. Next.
Milord.
Certified copy টা পেয়ে যেত।
Here, my lord, the petitioner's father was the.
No
defen-
caveat?
No, caveat.
Yes.
My lord, petitioner's father was the defendant of the title suit number 83 of 2004. And the,
What is the problem? What is the order you are
my lord,
challenging?
here, we have preferred, after my father died, a long days after, the wife of the plaintiff filed execution, only adding one son. There are 4 sons and 4 daughters, and started the execution. And when we got the information, we preferred appeal before the district judge at Howrah.
Against the judgment and decree.
Yes.
And then
And the stay application which is pending, and we appeared before the learned court and filed one application under order to 21 rule to 26, but which was not heard. It was kept in the record, and the direction was given to the commissioner of police for personal appearance for giving the estimation of the police cost, my lord.
No, but you directly filed an application under order 21 rule 12. Your appeal is pending.
Yes, my lord. There was no district judge permanent, so the appeal, the stay application was not heard by the learned church court.
All right, take down. A prima facie court case has been made out by the petitioner. It is submitted that instead of granting an order of a conditional stay of the title execution case, now instead of considering the application filed by the petitioners, public appellants in, what is the appeal number you have not given?
133 of
Look at your cause title.
in the first page, my lord, I have given the.
You have said about that appeal.
Yes, my lord. In the para number 1, my lord. And in the.
Come to the first page, the 0 page.
Yes, my lord.
In the matter of,
Revision of the.
you बोलना? The petitioner is, the category is agreed by an order dated May 17, 2023, which has been filed in title execution case number 4 of 2018. Arising out of the judgment and decree passed in title suit number 83 of 2004, pending before the, which is pending before the learned civil judge, junior division, 4th court at Howrah. The petitioner submits that aggrieved by the aforementioned decision passed in the title suit, judgment and decree passed in the title suit, the petitioner preferred an appeal before the learned district judge at Howrah. Where is it pending? Before the district judge?
Yes, my lord.
The said appeal was, the title appeal was registered as, no, the appeal was registered as title appeal number 133 of 2022. It is submitted that as there was no permanent presiding officer, the application for stay of operation of the judgment and decree had not been taken up for hearing. In the meantime, the execution case proceeded. Hence, the petitioners filed an application under Order 21, Rule 26 of the Code of Civil Procedure for a stay, conditional stay for limited period. The learned court, instead of taking up the said application, proceeded with the execution case and directed the Commissioner of Police or his authorized agent to be personally present before the court for compliance of previous orders. It is submitted that unless the execution case is stayed, the appeal will become infructuous. Next paragraph. What is the appeal? What are you saying that you were not allowed, you were not included in the appeal, in the suit?
Only one son is included, but rest 4 son and 4 daughter name was not included in
It
the
is
execution.
submitted that the petitioners have a good ground to succeed in the, good grounds to succeed in the appeal. Inasmuch as the judgment and decree was passed against only one of the heirs of the original defendant.
Of the original defendant.
One of the heirs of the original defendant, but the other heirs were not brought on record. Hence, this court is of the view that unless the execution case is stayed for a limited period,
Yes.
the appeal will become infructuous and will preclude a fair and just decision in the matter. As there is no caveat, the matter is taken up in the absence of the opposite parties. Stay of operation of the order dated May 17th, stay of operation, stay of all further proceedings in title execution case number 04 of 2008, which is pending before the learned civil judge. 04 of 2008, which is pending before the learned civil judge, Junior Division, 4th Court at Howrah. up to November 30. Let the matter appear on November 22nd at 3 p.m. Service upon both of the opposite parties and also their learned advocate appearing in the opposite party, and the learned advocates appearing on behalf, advocate appearing on the other side, opposite party. What is the suit for?
It is suit for cash proposition.
Recovery of cash possession.
Yes, ma'am.
How are how are you enjoying it? Are you a tenant or anything?
Yes,
like that?
ma'am.
What was your last paid
We are
rent?
the licensee of the
What was your
Jameen.
last paid rent?
Milord, no rent. We are the licensee of the Jamindar, and the Jamindar's daughter, after his demise, sold it to the present plaintiff.
But you have to pay occupational charges. It's a decree of recovery of possession and you are in possession.
Yes, ma'am.
Where is the property?
Milord, it is in Bakra.
Howrah.
Yes, Milord.
What is the area?
Milord, it is Bakra Noya Babaj area.
What is the size
Milord, 2 kakatha, Milord,
of land?
of land.
No house.
No house, Milord.
Oh, tale chalo. Yes. Clear it. Next.
Deeply.
Lordship, kindly pass over in this matter. Soboshachi Chatterjee has been appointed and he is engaged in court number.
Not today.
Not
Is there any caveat?
no,
But I'm telling you one thing. If matters are fixed at the top, please make yourselves available. Because I'm very hard pressed.
No,
You
no.
see, I'm shooing away learned advocates who want to do their matter in the mornings. I'm not allowing them to mention, then I will not adjourn. This is the last day. Please be careful.
kindly
everybody.
if you kindly pass over this matter.
He's coming. All right, I'm passing it over. You ask him to come back.
Great, great.
Next. Yes, please.
But in terms of the earlier order, first by
Mr. Tiwari, I can't take it up today. It's a fixed
Okay.
contested matter. Today there's a resolution.
no, I'm saying Manoj, what happened. I went to the learned advocate who filed the caveat. He has refused to take since Malad he has already resigned from the brief.
Maybe, but
So
you
I
have
have to serve the
Sir,
kindly
can I
pass the
pass
order
the
to all the and extend the interim order. Manoj.
up to when is the interim order?
And it's
31st July.
31st July. It will take some time because
Oh, this is that appeal
yes,
stage.
yes.
Right, take down.
7 my lord opposite
It
parties.
is submitted by Mr. Tiwari.
Go Thakurat.
Oh, sorry, Mr. Go Thakurata, that the revisional application could not be served upon the learned advocate who had lodged caveat, as the learned advocate informed Mr. Go Thakurata that he had issued a no objection. Next. Under such circumstances, let the revisional application be served upon each of the opposite parties and also their learned advocates. Interim order is extended up
Learned advocate already resigned. That is
in the court below.
court below he was conducting. I don't know Malad, who is appearing Malad, right now. Malad.
All right, tell you all the opposite,
parties.
by
That will
registered
suffice.
post with speech post with acknowledgement due, affidavit of service to be filed on the next date. Let this matter appear. But what about service upon them? I could not have given just the party.
Since my lord, he has already, my lord, lodged caveat, and I have to serve, my lord, because my client has received the notice after passing of order
Yes.
to all the parties, and my lord, kindly extend the.
Extended up to 30th November. ওই 22শে নভেম্বর দিয়ে দাও।
হ্যাঁ।
2:30 যাই হোক আর কি।
আচ্ছা।
ওই 2 PM দিয়ে দাও, পর এসে যাবে। Yes, next. Yes, Mr. Chatterjee. দেখো তো পাস ওভারটা।
There was a caveat on the last occasion.
Oh, then I can't pick it up.
My learned
Have you
friend,
served the caveator?
caveator was present on the last occasion. So, Lordship, I think
Sure. Devjit and Arnab.
Yes.
Because they're not today.
not today, but Lordship, the question is simple issue that here now he has challenged.
Not today. There's no point in
Lordship,
hearing
kindly
in their
keep it, keep
absence.
the matter
Not today,
intact.
tomorrow.
Same,
Monday,
same
yes.
position, Lordship, let it written. Otherwise,
Next. Not today. Not today. Not today.
Lordship, item number.
My lord, I am appearing for opposite
Which
party
one?
number 2 and 3, 20.
Come to Daco 20.
Lordship, item number 20, I beg to appear for MS Supreme Construction. I seek apology. On the last occasion, I took
We
time.
appeared on the last
No
occasion.
problem. So
Right.
anyway,
And
all right. Not today. It will appear on Monday in the same position.
Lord, very well.
Much.
20 to 34. Anybody without caveat? 35 to 50.
সেটা বলবে তো?
Lordship, actually in this matter, Mr.
He is also having some problem on Monday.
Sandeep Kumar
Lordship will
Bhattacharya is admitted. Item number 20.
just now.
So when can he be available?
Lordship, yeah, he has
He's in
to.
hospital.
He's in the ICU and today he has an operation, major operation. So, Lordship, then any date.
তাহলে দু
But,
সপ্তাহ?
At least 2 weeks time.
There is some urgency, my lord. A suit based on, my lord, unregistered agreement for sale. It's proceeding, my lord.
No, you go and pray before the learned court below. I am passing an order which will make it easy for you.
Lordship will remember Mr. Moinak Bose is appearing for the petitioner in this matter. Lordship rightly said that it is covered by NN Global matter, my lord.
No, that we will see now. On the prayer of the learned advocate who appears on behalf of the,
MS Supreme Court.
on the prayer made on behalf of the learned advocate who appears on behalf
Opposite
of
party
one
number
of the-
1.
Opposite party number 1. The matter is adjourned for 2 weeks. The learned advocate is undergoing surgery. The agony of the petitioners is that the suit will proceed in the meantime.
Yes, my is
The
proceeding.
petitioner is at liberty to pray for an adjournment under special circumstances. Let this matter appear on 1st August in the same position.
Much obliged. Much
Same
obliged.
position.
Much.
All right, thank you. Yes, 21 to 34. Thank you. পরেরগুলো ডাকো, এইটা কে এইটা? দাঁড়া। না ওরম হবে না, এই পুরোটা 35 to 50 বলো, কেউ আছে নাকি জিজ্ঞেস করো।
38, no caveat.
Yours is
44, my lord.
wait 38 or 44 ফাইল বার করো তাড়াতাড়ি।
Look, 44 is caveat is there. My lord,
No,
some
that is there হলে হয়।
my lord, kindly some
but
urgency is there.
Nobody wants to talk to
On
you.
third fixed
30.
before the
38.
44 টা ও বলছে 3rd এ ফিক্স আছে, এইটা 3rd August।
3rd August, the board has been fixed the date of hearing. my
তাহলে এটা 1st 1 তারিখকে
Any-
তোমার ইয়েতে নোট করো, 1 minute. Give the notice. আচ্ছা ঠিক
Yes,
আছে, 44 এ একটা record and order. The petitioner requests the court to take up the matter as the learned court below has fixed the next date of hearing of the suit on August 3, 2023. as there is a resolution and the learned advocate for the caveator is absent, the matter cannot be taken up. Let this matter appear on ওই যে আর্জেন্ট যেরকম 4-5টা করে আর্জেন্ট দিয়ে দাও, সেটি এটা কবে দেবে? 26th under the heading urgent motion.
Before the board, my lord, board of workup, not so. Board of workup, hearing has been fixed before the board of workup.
আচ্ছা, board of the learned tribunal or the board এর against এ তোর civil division হয় নাকি?
The tribunal rejected the order. Thereafter, I file and revision.
As the board of workup has produced. তাহলে করে দিয়ে তারপরে learned advocate for the petitioner is directed to serve a copy of this order upon the learned advocate appearing on behalf of the caveator and also upon আর কেউ আছে?
Board of workup.
As also on the board of workup. Yes, 38.
Milad 38.
38 এর file.
Milad the petitioner is Milad a publisher.
আর কেউ নেই নাকি এখানে বার করার জন্য? আমি তখন থেকে তো বলে যাচ্ছি 38, তুমি লিখছো কেন বার না করে? একই কথা বলে যাই, সেটাই শোনো না।
2764.
এই মুর্মু দিবলিপকে ডেকে পাঠাও ফাইল করার জন্য।
Milad the petitioner before the lordship Milad is a publisher. Milad OP number 1 is also a publisher and OP number 2 is Milad is the author. Milad will Milad no Milad Shatra Milad who writes Milad the biology books Milad for class 9 and 10. Now Milad kindly comes to Milad the agreement Milad where Milad the both the OP number 1
The issue
Milad the issue Milad I have filed an application Milad under order 1 rule 10(2) for striking of my name. Now Milad the issue crux issue Milad of the matter here Milad OP number 1 is the publisher, OP number 2 is the author. Milad they had an agreement inter se between themselves. I am not a party. Now Milad there is an arbitration clause. Milad what lawyers we usually do to entangle third parties so that we can circumvent that arbitration clause and come before the civil court, which is usually Milad easier way. Now Milad I am Milad another publisher. I am nowhere connected with the agreement. I am nowhere connected Milad with their dispute. Milad they had that dispute inter se. Milad the author and the publisher OP1 and OP2. Milad they filed a suit. Milad the OP1 filed a suit against OP2. Milad making me defend number 2 there.
What is the show me the plaint?
Yes,
What
Milad
have
the
they said
plaint.
about
Yes,
this?
plaint is at page 31, and there is
But
no.
there is scope for an interim order here.
Yes, Milad the matter has been fixed for the injunction hearing.
So let it be heard. If you have nothing to say, don't say.
I
How
have
does it matter to you?
I have prayed for Milad striking of my name.
So if that is not struck off, how
Yes.
does it matter to you? If
I have to continue. I have to continue. Milad Milad I may suffer an order of injunction then.
No, what kind of order of injunction?
Yes,
is
Milad
this?
I'll show Milad. Kindly says Milad.
Show me the
Yes,
plaint.
plaint page 31. Milad plaintiff is OP number 1. And Milad OP number 2 is Milad D1. Milad kindly see Milad I am D2. My lord will not find any allegation against me. Save and accept Milad. Save and accept paragraph page 37 para 17. Only one paragraph. No allegation against me. All along inter se between themselves.
Making any attempts to publish his books of life science or Jibon Vidya or any other books of similar nature through the. So you are the publisher.
I'm no
They are asking that no books should be published through you.
absolutely. Milad kindly tell us how Milad the dispute emanates from here.
That
The
is
agreement.
The issue is that if that he thinks or he feels that the books or the documents or whatever may be published through you as you are one of the publishers.
Yes.
Because of the problem that this publisher is having with the author, that is the restraint.
Milad that has been done.
That
There is no
can be
restraint. Milad that has been done.
Rightly rejected.
Milad, may I show the impugned order? May I show? Milad that has the case. Milad the learned. Milad the court below had found that there is no allegation against me.
No
but-
allegation is not against you.
No allegation
But
against
there
me.
is a fight between the author and the publisher.
That consists of an arbitration clause.
That is a different thing.
I cannot go and file section 8 because I am not a party to that arbitration.
You don't need to file an section.
Because I am
Please
in.
understand one thing.
Yes.
I and A and B have a fight over something.
Right.
A says which over a publication issue,
Right.
right?
Right.
He is apprehensive that the instead of now routing the publications through the publisher who has filed the suit in terms of a contract, he will go and publish through you. That is why you have been incorporated as a party, so that no steps of publication is taken through
Absolutely,
you.
absolutely.
So you are a necessary party.
Absolutely. But Milad, that agreement, Milad, on the basis of which the suit was filed, bears an Milad arbitration clause. They filed injunction application. Injunction was Milad refused on the ground that arbitration clause is present. And Milad order was passed for Milad so cause. Now, Milad, that injunction will come up for hearing. In the meantime, I filed an application stating that to circumvent the arbitration clause, so that Milad, they need not go before the Milad, the arbitrator.
So you have said a lot of things which is on the merits. Then how can you not be a
Milan,
party?
I have said that the dispute emanates out of the arbitration agreement.
All right.
And Milan, arbitration agreement party has to be Milan referred. The
Yes.
difficulty is that Milan, I am not a party to that. My lord can of course Milan say that I can
but
go and
you,
file section
in
8.
the answer to the injunction application, you can always say that I am not a party, I am not publishing through him. If you say I'm not publishing, your name can be struck out later also. But at this stage, he has a claim. Take
But Milan,
down.
kindly seize Milan the impugned order once. Kindly seize once. Milan. Page 24, the first annexure. Milan, kindly takes Milan page 29, the last paragraph. Page 29, last paragraph.
Yes, see, look at this paragraph. Court is right. That there may not be direct allegation against the defendant number 2, but the allegation against the defendant number 1 is very much attaching the locus standi of the defendant number 2 as being involved with the dispute
Right.
by between the plaintiff and for publication.
Kindly seize the Milan the agreement once. Kindly seize the agreement once. Page 57.
Here.
Here the Milan, they have said that he has violated and breached the agreement. The averments are there.
So, 1 minute. You have to understand we are in the stage of whether you are a necessary or a proper party, right? The plaintiff says that there is an agreement with regard to publication of his books with the publisher. The publisher breached that condition and is doing things contrary to the contents of the contract. And in that attempt, he is trying to publish the books written by this man, or the author is trying to publish the books written by this man through you. So that should not be done. That is his case. So you are a proper party, it's not a necessary party.
But Milan, kindly seize the agreement once. Milan, once.
Why should I look into that agreement? Because you
Milan,
are
now
not
what has happened? Now, I'm not. Now what has happened? Initially, Milan, OP number 2 filed a section 8.
Yes.
Now Milan, they have joined hands now. They have withdrawn section 8. Now Milan, they are proceeding with the suit.
So you say I will not publish his matters.
Milan, that is the difficulty.
Undertaking that the suit may be dismissed.
Section 8 has been now withdrawn.
You tell the court, I am not going to publish this man's books. That matter ends against you. Take down. The suit is going on against whom? Like you, only you.
No, OP.
You have a written statement. If then at that stage, if the court says you are not a necessary party, you will be out. Take
Milan,
down.
allow me to Milan, take that
I
defense.
will tell you. You allow me. The petitioner has challenged the order dated June 28, 2022, passed by the learned civil judge, learned
10th bench,
10th judge,
10th bench.
sorry, 10th, learned judge, comma, 10th bench, comma, City Civil Court at Calcutta, in title suit number 1445 of 2019. By the order impugned, the learned court rejected an application filed under Order 1, Rule 10, bracketed 2 of the Code of Civil Procedure, filed by the petitioner, praying for striking out the name of the petitioner. It is submitted that the petitioner was neither a party to the agreement between the plaintiff and the defendant number,
OP1 and OP2, Milan here.
defendant number and the opposite party number.
1 and 2.
No, plaintiff is the
Plaintiff is OP number 1 here and
the opposite party number 2. Nor was the arbitration clause in the agreement binding upon the petitioner. The petitioner is a publishing house under the name and style of and publishes various material under the name and style of Prantik as the sole proprietor thereof. Next paragraph. The learned court below rejected the application filed by the petitioner on the grounds that although there are no direct allegations between the against the petitioner, but the allegations and the cause of action of the suit filed by the plaintiff against the opposite party number 2 involved the petitioner as well. The plaintiff has alleged that in breach of the agreement between the plaintiff and the defendant number 1, the defendant number 1 would take initiative to publish the books through the defendant number 2 with oblique petitioner. Hence, reliefs have been prayed for an injunction against the petitioner from making any attempts to publish any further books of life science or Jeev Vidya or any other books of similar nature authored by the plaintiff, authored by the defendant number 1, oblique opposite party number 2. Under such circumstances, this court is of the view that the carriage of proceedings being in the hand of the plaintiff, carriage of proceedings being in the hand of the plaintiff has impleaded the defendant number 2, oblique petitioner, in the suit for proper for effective adjudication of the suit and for necessary reliefs which have been prayed for in the suit. The relief of injunction restraining the opposite party from publishing any books authored by the defendant number 1, opposite party number 2 cannot be granted in the absence of the defendant number 2, oblique petitioner. Hence, the petitioner has been rightly impleaded. The order impugned does not suffer from any irregularity. Next, the petitioner submits that the petitioner has never made any attempts to publish any book.
No.
Then-
Books is being published. Well, allow me to file Miller written statement with taking all those defenses. Though that will be a wrong submission on my part.
The issues involved in the revisional application are not to be adjudicated at this stage. The petitioner is at liberty to take all points relating to the merits of the suit in the in his written statement. Yes, disposed of. The court has not gone into the merits of the issues involved. Yes, next.
Milad, along with that, can you also provide me? Along with that, also provide me with one more liberty. Well, Milad provided that. Milad, now Milad, non-party to the arbitration clause also can file Section 8. Supreme Court has said in chair
That is up
properties.
to you. That
No,
I
Milad,
will not say.
written statement or Milad any other. Milad, kindly
Take all
yes,
these points at any stage in any proceeding.
problem.
The petitioner is at liberty to take the points which are available to him under the law in any stage of the
Yes.
proceeding.
And this
Yes,
I'll
next.
get stuck. Obliged.
Even if it is sent for arbitration, you can say this. In the
Yes, yes.
arbitration, it will be only
No,
between
Milad,
them
written
anyway.
statement, Milad, the court may say that you can only file written statement. So if I go and file Section 8, I may get stuck with that. That's the only reason. Very good. Obliged.
Yes, all right. Next.
And 40.
No caveat?
No, I am for the opposite party.
তাহলে আবার কি হবে?
One thing, I know this situation, today's situation. One thing, I am praying some upliftment of the.
Shabash,
No, no, man, why?
শুভদার কাছে একটা করতে পারতে।
No, well, kindly give me 1 minute time. Well, suit for eviction up till now, 15 lakhs and odd is due.
From where? Wife?
Suit for eviction from the tenant. 15 lakhs and odd is due.
Additional charges
Yes. Now,
elected by court.
when the suit was pending before the trial court, no amount was paid. Suit
Acha,
decreed.
if I upgrade, isn't that an adverse order?
Because the matter will retain because no order is passed in that.
So who is the learned advocate for the petitioner?
Mr. Sumana Sinha, initially she was led by Mr. HON'BLE Krishna Saha. Now, I had a talk with Mr. Saha yesterday. He said he is no longer appearing in this.
Give her a notice and I'm fixing it on. No, petitioner's নাম আর তোমার নাম সেম দেখেছো? তাহলে তো আপগ্রেড করতেই হবে। Yes, take item 40. Just take down. The petitioner prays for urgent listing of this matter on the ground.
Opposite party.
The opposite party prays for urgent listing of this matter on the ground that around rupees 15 lakhs as occupational charges is due and pending. What have you challenged? What have they challenged?
The learned judge in the lower appellate court enhanced the amount to be paid. That has not been paid. Then an application for modification that has been allowed against that.
Today is not the appropriate day to take up the matter. Let this other listing bolo na tale bolo praise that the matter may be taken up on urgent basis. In view of the resolution of the bar, the matter cannot be taken up today. Let this matter appear. Urgent list দিয়ে দিও 4-5টা যেরকম থাকে 27th July. The learned advocate on record for the petitioner is directed to issue notice to the learned advocate on record for the
Petitioner.
opposite party to the petitioner. Yes, all right. Opposite party আসছে, হ্যাঁ? Yes, next. 27 তারিখ, হ্যাঁ? এই 44টা কবে রেখেছিলি পকেট? 26 না? ঠিক আছে। Yes, next.
Your Lordship, I am appearing on behalf of the petitioner.
Caveat?
Yes, my lord, there is a
তাহলে আর
caveat we have served.
Your
Your Lordship,
এখন সবাই বলে আপগ্রেড কর।
my lord, in fact, I would have made the prayer.
আচ্ছা 45টা দিয়ে দাও।
45, my lord, yes, Lordship, some precedence. my lord,
একই অর্ডারটি করে দাও। খালি অপোজিট পার্টি আর পিটিশনারটা ইন্টারচেঞ্জ করে দেবে।
Lord, 42, Lord.
42.
দাঁড়াও এক সেকেন্ড। এটা কি 45?
45, your Lordship.
ওই 26 তারিখ 27 তারিখ যে কোনো একদিন রেখে দাও। না একটা ডেট বলে দাও তো নোটিশটা।
I'll issue a notice to the opposite party.
26?
My lord, may I submit the affidavit of service, my lord?
না, একদমই না।
Okay, my
Lord,
lord.
42.
Same order as the earlier matter, just interchange the opposite party and the press. না ওগুলো লিখবে না। আচ্ছা ঠিক আছে আমি বলে দিচ্ছি। The petitioner prays for urgent hearing of the revisional application. In view of the resolution of the above, matter cannot be taken up today. Petitioner is directed to issue notice upon the learned advocate for the caveator. Stop. Let this matter appear on.
Any date, my lord. I am led by
26.
Mr. Basu, Shoptangshu, sir.
আরে বাবা, সপ্তাংশ বাসু করলে listing will be difficult. If you
26th,
do
my
it,
lord.
yes.
Yes,
2
your
minutes matter over.
Yes, your lord. Oblige, my lord.
Yes, for
Item number 42, Lord, I was waiting, Lord.
বাড়ি থেকে বসে হবে না। অসম্ভব। That is not the idea. সবাই কষ্ট করে আসবে তুমি বাড়িতে বসে আরাম করে করে মামলা করবে। That is not the idea of today's resolution. What is it?
Lord, same prayer, Lord. What was made in 30, Lord, 40 and 45, same
I'm
prayer.
reading you.
Yes, yes.
Oh, your advocate on record is here.
Yes, yes.
Same prayer করে দাও পরেরটা 26 তারিখ।
I'm grateful.
But this is wrong, you know.
Nothing can be done. Nobody can come out of the house. What is the situation here?
Mr. Kormokar,
In Shambhadar, all roads are blocked.
today was the easiest travel. but all
I'm there,
those who have
I'm there.
All
Advocate on the
He's
call.
from Howrah.
Howrah,
from
I
Howrah.
come from new town, which is the farthest.
I
একদম
come from
I'm
I
from
come
the
from
Howrah.
Shambhadar. I don't get the bridges.
Oh.
Your lordship gets the flyovers. I don't get.
flyover is most jam packed. Yes.
Lordship, item number 33.
আবার কি হলো? তোমার কোথায় ছিলে?
I just went out.
What you want?
Lordship,
27 তারিখ। Is there any caveat?
no, your lordship.
করে দিচ্ছি। 33
Instead of
ফাইল
26, can it be 27th?
আচ্ছা, আগেরটা 27 করে দাও।
27
Hey, আচ্ছা, ঠিক আছে, ঠিক আছে, let it be on 26. Let it be 20.
42. Item
42.
42. Yes, 42.
Yes.
26.
26.
না, 26 ও 26 বলছে। Give 33. ফার্স্ট লটেই থাকবে না? জয়রাম কনস্ট্রাকশন।
Yes, your
What
lordship.
is the matter?
Lordship, actually, I am challenging this.
তোমরা খোঁজো, বলুক না।
Lordship, I am challenging the order of the lower court, learned civil judge, senior division, Barashat. Order dated 4th May 2022, where he has accepted the report of a local commissioner for inspection, in which I was not present at the time of conducting of the commission.
You got notice or you didn't get?
We did not get any notice of the. I'm the petitioner, and in the main suit, we are the defendant number 1. Defendants.
No notice was given to you?
No
What-
notice was given.
What does the report say?
Your lordship, I will just, I want to give the commissioner's report.
Take it out.
Here only it is mentioned in this final commission report.
No, does it say anything?
He has
about-
admittedly said that not served to the learned advocate of the defendants due to non-availability of the service of the address of the, and still he has went ahead and conducted the commission.
Why your address was not available? to
No,
pay?
that is because they have plaintiff has filed the wrong address in the cause title.
ছুটির দিনে এসছে। The petitioner submits, the petitioner, who is the defendant number 1, in title suit number
219 of 2020.
219 of 2020, which is pending before the learned civil judge, senior division, 2nd court at Barashat, has preferred this revisional application, challenging. What have you challenged?
We have challenged this commissioner's report in which this order dated.
Local inspection.
Yes, I have challenged this order of the.
Local inspection.
Yes, your lordship. And
Has this
I have challenged the order of.
paid for setting aside of the order dated May 4, 2022, passed by the learned court by which the objection of the petitioner with regard to admissibility of the report of the local inspection. Anyway, that's not admissible in evidence. Report of local inspection has been acceptance, admissibility কতটা ভুল হবে, acceptance of the report of local inspection was rejected. It is submitted by the petitioner that the learned advocate commissioner admitted that the notice of the inspection could not be served upon the defendant number 1. A prima facie case has been made out, stay of all further proceedings in title suit number so and so, 30th September, 18 September, 2 p.m. No. Service, সবার উপরে. Who are the plaintiffs? How many are there?
There are 6 plaintiffs in that main suit.
All the opposite parties and also the learned advocate. Serve upon all. Yes, next.
Lordship, item number 46, I am not briefed about that, so if it can be kept not today and
All right, don't mention.
and the
Everything is
next date in the lower court is 5th August.
No, then it can't be. If you're not appearing, don't go and do it for somebody else. Yes.
And Lordship, in this matter, this previous matter, the next date is 24th of July, Monday. So
That's
if an urgent copy be uploaded on the,
I will see what I can do. May not be you liberty to communicate this order
okay. Much obliged, your Lordship.
and part the server copy also. Yes. Next. তারপর কত অব্দি ডাক হচ্ছে? দিলীপ ওখানে বসে ডেকে যা তো টাইম লাগছে অনেক তাড়াতাড়ি
48 Millard, I am for the petitioner. 48.
দিতে বসে থাকলে সরি
Millard, no, Millard, what happened, Millard? The argument is fixed on 27. That's why your lordship was pleased to update the matter. My lord.
everybody is coming to court and you are such a young boy, you can't come.
No, Millard, there is caveat, Millard, in any way.
তাহলে গুলি মার।
Millard, the 27th is the date finally for argument in the suit. That's why I mentioned the matter, Millard. The lordship was pleased to update the matter.
48, when did I then it must be appearing on the next day.
On Monday, 25th.
আচ্ছা তাহলে record an order. Please give your notice to the learned
Already served on last Friday.
Bhattacharya.
I will give another notice.
The learned advocate for the petitioner submits that. What is the next date?
27th. Last date was on 17th.
What your WS was not accepted.
Item number 48, Millard, I beg to appear for the opposite party. Number one, the plaintiff opposite party. Kindly takes it up on Monday. Takes it up on Monday.
I'm taking it up on Tuesday.
Very well.
Tuesday, very well, very.
All right. Both the council pray for listing of this matter as an urgent motion on 25th. All right.
I'm great.
Next. না আর্জেন্ট মোশন অ্যাজ এন আর্জেন্ট মোশন এই এগুলো কিন্তু যেগুলো বলছি ওই টপের আগে যেগুলো দিয়ে দাও তার পরে থাকে তো আর রিটার্নেবল তো আজকাল আমার মনে হয় বেশিরভাগ আমি 2 PM এর পরেই করছি যেগুলো আছে অলরেডি আছে এগুলো আগে উপরে দিও কারণ এই টপ গুলো তো কন্টেস্টেড এগুলো টাইম লেগে যাবে মোশনস গুলো আগে দিয়ে দাও ইয়েস অলরাইট নেক্সট প্লিজ
49, 50, 51, 52, 53. I am for the petitioner, ma'am.
Is there any caveat?
No, ma'am.
Other side?
No.
Nobody gave you letters?
No.
Chalo, tako. 53, what is it? You say.
No, order 39, rule 1 2 rejected by, I am for the defendant of the suit, my lord.
It is an appealable order. The order impugned is an appealable order. The order impugned is an appealable order as the petitioner has challenged the ad interim order of injunction passed in mispreemption case number 3 of 2022. Revisional application is dismissed. Petitioner is at liberty to take back the certified copy of the order impugned upon furnishing a photocopy thereof. No. Next. এই কি খাবার দিচ্ছে গো আজকে এইবার লাইভটা বন্ধ করে দাও অনেক হয়েছে লাইভ